Welcome once again to our continuing YouTube video series on Unanimous Shareholders Agreements. My name is Christopher Neufeld of Neufeld Legal, and in this particular YouTube video I'll be discussing the most common error or common problem I find with Unanimous Shareholders Agreements that are out there, and that clients come to me after, oftentimes years after they've been put together, and they're operating a business, the business will become successful, and issues arise or dimensions arise with respect to that particular business that needs the attention of a new lawyer. Now, so what is the single biggest issue that I find with unanimous shareholders agreements? It's that there's far too many cookie cutter agreements out there. And when I say cookie cutter agreements, what I'm talking about is templates. They go to a lawyer, they do it themselves, and they get a unanimous shareholders agreement. That is a templated agreement. And it's designed almost as a one-size-fits-all, or sometimes the lawyers will have 3 or 4 different versions, or so it's 3 different types. Depending on what type you are, I'll slot you in one or the other or the other. Because sometimes you have 2 shareholders that are equal position. Sometimes you have 3 shareholders, so it's not really a 50-50 split, or you have majority and minority shareholders in there. But is that the only scenarios that a business has? No, it's not like that. There should be as many shareholders agreements as there are businesses out there. Really, there's no 2 businesses. There's so many different specific and unique elements specific to your business that you can't be relying upon a cookie cutter singular template agreement where you all only fill in your names and you follow through on what it is that's in there. Yeah, lawyers want to get paid and take the simple way out of it because oftentimes, I don't know, their clients don't know better. They'll put some stuff in there, they'll jazz it up a bit, but really there's nothing of significance or difference that makes the particular agreement really work for the shareholders who are involved in the business. And this is problematic for yourself because it doesn't do what it should do and help advance the business and help better resolve disputes. There are so many unique factors that are particular to your business, but also particular to your business relationship with your fellow shareholders, where you are financially, where you are from a contribution standpoint, and a range of other issues that need to be considered in this whole unanimous shareholders agreement. The unanimous shareholders agreement is such a definitive document, a controlling document for your business, that you can't simply let it to chance. Save a couple dollars at the outset only to have problems down the road. Because as I've said many a times, in particular in these YouTube videos, you're only going to get really a good chance to define the relationship of the business between shareholders, or as you might call it, business partners, at the very outset of the business. It's going to be difficult down the road, especially if different shareholders have moved into different priority positions, especially when one is contributing more than the other. Because when you start contributing more and there's an unequal balance in the amount of input, whether financially or work-wise or conceptually, the party that is not in doing the greatest of contributions is not going to necessarily want to reduce their position. So you have to do it at the outset. And unfortunately, if you've taken on a cookie cutter template agreement, you're pretty much going to be stuck with it because they're not going to want to change it unless there's circumstances or out of the goodness of their heart, which is difficult in business, they agree to do that kind of change. Don't expect it. I wouldn't, because it's not a wise move to anticipate somebody going against their personal best interests, especially when it comes into business. And on top of that, a lot of people, shareholders and partners alike, will feel that you're trying to undervalue their contribution And meanwhile, they will overvalue their own contribution. So you're not going to have a shift in it. You're going to be stuck with this cookie cutter template agreement. So what do you have to do? What I strongly suggest is go and work with a knowledgeable, experienced lawyer who understands shareholders agreements, but also is prepared to work with you and understand what you're attempting to achieve in your business, what your goals are, what your contributions are, what your challenges are, what the inputs are, not only currently, but the expectation going forward, what your expectations are of the business as you move forward and your own life as you move forward. Do you see exiting the business yourself in a short period of time, a long period of time, or almost never? Do you anticipate holding on to the business for a considerable amount of time and simply selling it as a whole? Or is it something that's going to bring in new shareholders and new business partners? Or is it going to potentially become an IPO, an initial public offering? Is that what the aspiration is? Or is it something that it's going to be a takeover target? These are the kinds of considerations you need to be putting in play. And then you work with your lawyer to build out those things. And also what your lawyer should be doing is working with you to identify other aspects that you might not have considered. Aspects that you start to look at, but there are layers and layers and layers. They're not overly complex, but they have to be addressed and addressed properly. And unfortunately, if you're using a cookie cutter template agreement that are all over the internet and that are in almost every business lawyer's archives, you're not necessarily going to be getting that. You need something that is specific and unique to your business and your business relationships. And that is why cookie cutter template unanimous shareholders agreements are probably the singular biggest problem for businesses with respect to what they have in the way of a shareholders agreement. Yes, it's better than having no shareholders agreement. I'll agree with that for the most part. However, why are you settling for second best? Why is your company and your aspirations settling for second best when you should be striving for something better? Because this is your business and it really should be protecting your interests. Yes, it should protect your other fellow shareholders' interests as well, but they have to be contributing and they have to be putting in to the amount that's expected of them. So that is why we strongly, strongly, strongly recommend you work with an experienced business lawyer who understands and has worked with many unanimous shareholders agreements and understands the conceptualization of working beyond the cookie cutter template. Yes, it's an important factor in the process, but it's only a part of it. It does not necessarily bring in the unique specific elements that need to be drawn into this agreement. And that is what we're trying to address. And that is what I try to address with my clients so they get the most of the agreement. And by getting the most of the agreement, hopefully they get the most of the business and the business's potential, because it's an invaluable tool for moving forward. Hopefully you have found this YouTube video informative and provides you some guidance as to how you approach your own development of a unanimous shareholders agreement. We're always available to serve you should you be looking for experienced legal counsel who understands the importance of going beyond the cookie cutter template unanimous shareholders agreement. And you can reach me at the contact information below this YouTube video. At the same time, we hope you have found this video informative irrespective of how you go. And we wish you all the best, as always, with your business endeavors and make the most out of it. Thank you.